Commercial Law Glossary. Letter A. Accord and satisfaction are contract's terms for when two parties in a contract agree to accept alternate performance to a pre-existing duty, obligation, under the contract, and after the completion of this newly agreed upon performance the contract is satisfied. The excusal of a party from the initial performance which the contract mandated is called the satisfaction, and the new performance which was agreed upon is called the accord. Acquirer is a mergers and acquisitions term, which means an individual or business who secures the ownership of assets such as property, stock or other interest. Acquisition is a mergers and acquisitions term, which means to seize ownership of the business interest by purchasing it. In corporations this would involve buying enough to have a majority of voting shares, 51%. Agency is a contract term which involves an agent and a principal. The principal grants authorization to the agent to act on behalf of the principal, to carry out certain actions approved by the principal, which limits the scope of the agent's authority. For creation of agency as well as the different types of agency agreements continue through our glossary. Agreement is a contract term, which means two or more parties have mutually assented to be legally bound by the terms set forth in a contract, while all parties were competent and entered voluntarily. Alternative dispute resolution is a general law term that refers to parties who would be heading toward litigation, instead seeking an out-of-court arbitration from a neutral third party to resolve their dispute. This is often done to save time and money. Amalgamation is a business law term which refers to the joining of multiple firms together, which forms a new conglomerate or organization. Angel investor is a corporation's term which refers to wealthy individuals or small groups of individuals who provide startup capital to firms, but who often play a minimal role in overseeing the day-to-day operations or management of the firm. Anticipatory breach is a contract term which is also sometimes called anticipatory repudiation and occurs when a party is not yet in breach of a contract, but there is evidence that a party intends on betraying the terms of the contract. This allows a party to file a claim earlier than general contracts laws would allow. Antitrust refers to the laws which are intended to increase laissez-faire economy and a free market system by limiting monopolies and monopolistic practices. Apparent authority is a contract's term which states that a principal is liable for an agent's acts or omissions to act, which lead a third party to reasonably believe that the agent has the authority or power to conduct the specific piece of business. Appraisal is a sales term which refers to the determination of an item or property's worth, or acceptability, based on analysis which uses certain expert criteria. It is often used to assess damage to an asset, which will help dictate the amount needed to repair it, by comparing the current fair market value to the former fair market value. Arbitration is a general law term that means parties to an action for future action use a mediator, neutral third party, instead of a court to resolve the dispute. If both parties agree to be bound by the decision in the arbitration contract's laws or applied, and the arbiter's opinion becomes as binding as a United States court would be. Arm's length dealing refers to the distance from personal contact or familiarity one has with an interest they are handling. In commercial law it is used to differentiate from an arm-in-arm dealing, which more often looks like a conflict of interest.
Free content by ContentBinger.com.